my fellow colleagues on the dais. I want to thank the committee for their work and consideration of this bill, and I accept the committee amendments. And I believe we have witnesses coming on the phone. On the phone. We'll have witnesses on the phone. Okay. So there's been a lot of misinformation about this bill that's been spread by the opposition. Therefore, I want to be very, very clear about what this bill does do. This bill is specific to pregnancy and pregnancy outcomes. Specifically, this bill will ensure that no one in the state of California will be prosecuted for ending a pregnancy or experiencing pregnancy loss. In the past 2 decades, at least 1,300 pregnant people have been criminally prosecuted for having miscarriages or stillbirths or self-managing an abortion. California is not exempt from this. Despite clear law that ending or losing a pregnancy is not a crime, prosecutors in this state have charged people with homicide offenses for pregnancy loss. 2 examples are the cases of Chelsea Becker and Adora Perez, 2 California women who were recently prosecuted and imprisoned for their stillbirths. These charges were only recently dismissed and or vacated, and only after these women were behind bars for months in the case of Chelsea Becker, and years in the case of Adora Perez, who is still currently in jail pending charges. AB 2223 is intended to protect against the criminalization of pregnancy outcomes, and people should not be subject to prosecution for any tragic situation that may happen during their pregnancy. This is the intent of this bill. However, the opposition has created a narrative that this bill legalizes infanticide, or quote unquote, the killing of babies. That is simply not true. This bill does not legalize infanticide. Specifically, as it relates to perinatal death, this bill protects parents who are experiencing extremely tragic pregnancy outcomes. As parents experience tragic situations, they should be supported as they mourn their loss and not criminalized. No person should have to endure prosecution as they grieve a tragic loss that happened during their pregnancy, and this bill provides those protections. Reproductive justice in California includes clarifying that nobody will be prosecuted for any pregnancy loss or pregnancy outcome. Therefore, AB 2223 will remove outdated provisions requiring coroners to investigate certain pregnancy losses, clarify that the Reproductive Privacy Act prohibits criminalization of pregnancy loss and pregnancy outcomes, and create a private right of action for people whose rights have been violated. I want to thank our sponsors, the ACLU California Action, Black Women for Wellness Action Project, California Latinas for Reproductive Justice, If When How, Lawyering for Reproductive Justice, NARAL Pro-Choice California, and Planned Parenthood Affiliates of California. Witnesses testifying with me today on the phone are Samantha Lee with the National Advocates for Pregnant Women and Farah Diaz Teo of If When How, Lawyering for Reproductive Justice. And I would respectfully ask for an aye vote.
Thank you. I do have those 2 witnesses listed. Farah Diaz-Teo, are you with us?
This is Samantha Lee from National Advocates for Pregnant Women. I'll actually be going first.
Okay, go ahead then.
Thank you. I'm a staff attorney with National Advocates for Pregnant Women, and we were some of the attorneys who represented Chelsea Becker against the murder charges for her pregnancy loss. I would like to read for the committee a statement from Ms. Becker about her experience. My name is Chelsea Becker. I was incarcerated in Kings County Jail for more than a year, from November 6, 2019 until March 10, 2021, while I was awaiting trial for first-degree murder after experiencing a stillbirth while addicted to methamphetamine. I have read the proposed amended bill, and based on my experience, I believe it should be passed. Experiencing the loss of my baby alone caused a lot of trauma for me, and while I was in custody, I was unable to receive the proper counseling to help me with the grief process. Even with the counselors at the jail, I was afraid anything I might have said to them would be used against me in court, so I suffered alone. While I was in jail, my youngest living son, whom I had custody of up until this time, had been taken into CPS and was later adopted. If the hospital had never involved law enforcement due to this stillbirth happening, I would still have custody of my son. The charge wasn't dismissed until May 2021, and by then the adoption had been finalized months prior. My experience with the justice system in Kings County was detrimental to my mental health, and I feel that I was failed deeply. If this bill is passed, it would prevent other people from experiencing what I did in being prosecuted and punished for something that could have happened to anybody. I hope that in the future, no woman will ever be prosecuted for losing a pregnancy. As National Advocates for Pregnant Women, I would like to emphasize to the committee that about 15% of all known pregnancies end in pregnancy loss. This is a fact of biology, not behavior. Methamphetamine did not cause Ms. Becker's pregnancy loss, nor could it have. Pregnancy loss is so traumatic already, and a case like Ms. Becker's multiplies that trauma exponentially. Even as she ultimately won her case and regained her freedom, she spent 16 months in jail during COVID, she fought the charges for 19 months, and she lost her older child to the system. Ms. Perez remains in jail facing murder charges for her pregnancy loss. And about 1,250 people nationwide have faced criminal charges because of their pregnancy in the past 15 years. In order to prevent this from happening to anyone else in California, we strongly urge the committee to give its full support to this. Thank you.
Thank you. And then Farah Diaz-Teo.
Good morning, Mr. Chair and members of the committee. My name is Farah Diaz-Teo, and I am Senior Counsel and Legal Director at If When How, Lawyering for Reproductive Justice. There, my work contends with a reality that may seem unthinkable in the contemporary United States, in which people who wish to make abortion a crime claim is a fiction. We defend people criminally prosecuted for their own abortions and stillbirths. AB 2223 addresses this issue directly, ensuring that nobody in California is investigated, prosecuted, or incarcerated for ending a pregnancy or experiencing a pregnancy loss. California has long been a leader in ensuring that people have access to abortion care and has strong legal protections against prosecutions for miscarriages and abortions. But the recent cases of Chelsea Becker and Adora Perez, both charged with homicide for losing their pregnancies, show that more needs to be done to protect Californians' reproductive freedom. These prosecutions were part of a national trend that we expect to escalate if the Supreme Court overturns or further undermines Roe v. Wade. Through the cases we work on and the dozens of cases that we've meticulously researched, we've learned a great deal about how people end up criminalized for losing a pregnancy or self-managing an abortion. We've learned that where there's ambiguity in the law, and sometimes even when there isn't, state actors motivated to criminalize people for their reproductive outcomes will find any pretext to do so. We've also learned about who is affected. The harmful consequences of these intrusive state actions are borne most heavily by Black, Indigenous, and other people of color. These communities are far more likely to experience adverse pregnancy outcomes due to inequities and marginalization in our healthcare and social support systems, and are more likely to already be under the surveillance of punitive state systems. And they're more likely to be viewed as suspicious upon seeking healthcare. AB 2223 removes any chance of ambiguity, making it abundantly clear that people's reproductive lives should be free from civil or criminal penalties. This bill also includes a private right of action to enable people who've experienced a violation of their rights to seek accountability using the civil justice system. We urge the committee to support this bill and take an important step toward ensuring that California remains a state where people can seek reproductive health care for any pregnancy outcome without fear of criminalization. Thank you.
Mr. Chair, we have no further support in queue at this time.
Thank you. We will now move to opposition. Those who would like to speak in opposition, please come forward.
My name is Susan Arnall. I'm a California attorney and vice president of legal affairs at the Right to Life League, America's first pro-life organization representing 52 member pregnancy help clinics, centers, and maternity homes in every one of your districts, and tens of thousands of pro-life voters across the state of California. As the bill analysis points out, there is so much wrong with AB 2223. First, California Penal Code Section 187 already prohibits prosecution of abortion. Even a botched late-term abortion would not be actionable. Second, this bill prevents investigation and prosecution of anyone, not just the pregnant person, who intentionally murders an infant, even weeks after birth. Here's how. The bill blocks the use of the coroner's investigation and findings into a baby's death in any criminal or civil action and against any person, not just the mother, but anyone who was involved in any way with the fetus's death. Then the bill goes farther. It restricts the use of the coroner's findings related to a baby's death, not only for miscarriage, stillbirth, or abortion, but also for, quote, perinatal death due to a pregnancy-related cause. Existing California law defines perinatal as up to 1 month following delivery. The bill analysis admits this on page 10. The author's recent amendments do not cure the problem, as it still remains vague and overbroad and ill-defined and with no meaningful limits. Finally, these provisions directly conflict with the existing California Health and Safety Code section 123435, which protects the rights of an infant prematurely born alive in the course of an abortion. An infant born alive holds the same rights as an infant born spontaneously. AB 2223 will make this section null and void by prohibiting the investigation of that infant's death. The bill analysis does not address this conflict of law. That's very troubling. Finally, it is particularly troubling that this bill tramples on federal immunity and conflicts with pre-existing California prosecutorial immunity as well. For all of these reasons, we oppose AB 2223. Thank you.
Thank you. Next, please. Go ahead, please.
My name is Katie Glenn, and I'm an attorney for Americans United for Life. Thank you for the opportunity to testify against this bill. Even with the analysis, we still don't know what the bill covers. The bill says the state shall not deny or interfere with the fundamental right to obtain an abortion, but what does interference mean? Notorious Philadelphia abortion doc Kermit Gosnell spent decades performing unsafe, unsanitary, and deadly abortions before finally being charged and convicted with first-degree murder. Staff of the Pennsylvania Department of Health testified that they believed any inspection or regulation of his clinic would interfere with access, even as they knew what was going on. I bet he wishes he lived in California. Earlier this year, a bill in Maryland, also using the word perinatal, was pulled after the sponsor was unable to answer basic questions about its intent. What we know is that no definition of perinatal stops at birth. If state-sanctioned infanticide is not the goal, then this bill needs amending. Numerous California laws could be impacted by this bill, including parental rights, estate and criminal law, and born-alive protections, but there is no discussion in the rush to get a gold star from the abortion industry. Law enforcement will be barred or deterred from investigating newborn deaths under the bill. In preparing this testimony, I read numerous stories about babies thrown in dumpsters. But rather than expanding California's safe haven law, this assembly would prevent law enforcement from investigating horrific crimes. The analysis says that law enforcement can investigate, but only until they find evidence of the mother or anyone who's helping her's wrongdoing, at which point they open themselves up to legal liability if they pursue the case. If abusers and traffickers know that crimes related to abortion or childbirth will go uninvestigated and unpunished, it will lead to more cases of child abandonment and death and more harm to pregnant women. Infanticide is an act or omission that kills a helpless baby. It is also the logical next step to be an abortion sanctuary. If a baby has no right to life at 39 weeks, and if California asserts no interest in defending or protecting that child, then why would a right attach just because the child draws breath? What's the difference? Both need nourishment and protection to survive. Neither can care for themselves for years. Vote no on this confusing, overbroad, and dehumanizing bill.
Thank you. All right, we will now move to others in opposition. We will not take further testimony, but only name, affiliation, and opposition to the bill. We'll start in the hearing room. And then move to the phones. I'm going to allow a maximum of 30 minutes for this section.
Greg Burt with the California Family Council, in strong opposition to this infanticide bill. Thank you.
My name is Jonathan Keller, president of California Family Council. I do want to thank Assemblywoman Wicks. I know these hearings are contentious, but I wanted to respectfully oppose this bill.
Thank you. Operator, we are past our time. You can close the lines for opposition. I'm now going to bring it back to the committee for questions or comments. Questions or comments? All right, seeing none. Oh, Mr. Kalra.
Thank you, Mr. Chair, members, and to everyone that spoke in support and opposition. Obviously, an issue that brings out a lot of emotion, but I would like to start by thanking the author for bringing this important measure forward, as well as the committee for the suggested amendments. I think that again, fine-tune some of the language and make it very clear what the intention is and is not of this legislation. As we discussed the impacts of criminalizing pregnancy outcomes, it's imperative we recognize the disparate impact on communities of color and the adverse health implications that come with it. These investigations or prosecutions run the risk of harming a person's health, livelihood, and ability to care for their families. And when we police pregnancy outcomes, we isolate people from their communities and their loved ones, which makes getting medical care even more difficult, if not impossible. Medical professionals, including the American Medical Association, the American College of Obstetricians and Gynecologists, and the American Public Health Association, oppose the criminalization of pregnancy loss. And when people fear arrest and criminalization, they're less likely to seek care and support when they need it most. Furthermore, the risk of civil and criminal charges for pregnancy are higher for people who are already targeted for surveillance and criminalization, including Black, Indigenous, and other people of color, immigrants, LGBTQ people, young people, people living in poverty, and people who live at the intersections of these various identities. It's already a traumatic experience for women to have a pregnancy loss. Let us not layer the trauma and punitive weight of the criminal justice system on top of the trauma that women and families are already facing. And for those reasons, I respectfully ask for an aye vote and will make a motion to move the bill.
Thank you. We do then have a motion. Is there a second? Second. And a second. Thank you. Other comments? Ms. Davies?
Thank you, Mr. Chair. I just want to bring something up in regards to this. Obviously, it's a controversial bill, and I can tell you that my office, like I'm sure a lot of yours, have had calls nonstop. And I think it's important as a body here that, I got a lot of calls from people from my district, but I also got a lot of calls from other people's districts. And some of the calls were saying that if I don't live in their district, they don't take, my opinion or my position. And I just want to remind us, because right now we do have a lack of transparency that the people believe in right now, and a lack in trust. So having each voice heard is so important, not to mention that when I vote for my district, but I'm also voting for every entire Californian, and that their voice is important to be heard, whether they're in my district or not. And I just think that we can do a little bit better job, but I thank everyone because I know this is important to you, that you're hearing their voices. So just want to make sure transparency is out there so that we can build the trust back. Thank you.
Thank you. Other comments, questions? Ms. Wicks, you may close.
Well, I want to thank the committee here, thank the consultants, thank the chair, and the comments from Mr. Kalra, and as well as agree with the sentiments around transparency and ensuring that we hear everyone out. I know that this is a very passionate subject, one that I'm involved in, and obviously have a certain point of view, but I respect other people's points of view as well, of course. I also want to just clarify, and I made these clarifying remarks in my opening, but just want to reiterate them. This is not a bill about infanticide. And I'll give you a tangible example of something that has transpired. There was a woman who was 8 months pregnant. She was in a very terrible car crash. They had to have an emergency C-section, and unfortunately the baby died, and she was prosecuted for that death. She should not be charged or prosecuted for any kind of homicide or manslaughter in that situation. That was a pregnancy-related outcome. So that's what we're trying to guard against here. And the fact that we have 2 women recently in California who have been persecuted for the loss of a pregnancy in California in 2022 is not okay. And I know this is a hot button topic across this country, but I know where I stand on this, that I believe that women should have access to safe and legal abortions, that women should not be prosecuted for, any kind of pregnancy-related outcome, loss of pregnancy, et cetera. And so with that, again, I will hear anyone who has support or opposition, but I know where I firmly stand on this issue, and I would respectfully ask for an aye vote.
Thank you. We do have a motion and a second. That motion is due pass as amended to the Health Committee. Call the roll, please.
Stone?
Aye.
Stone, aye. Cunningham? Davies? No. Davies, no. Holden? Holden, aye. Kalra? Kalra, aye. Mathis? Maienschein? Reyes? Aye. Reyes, aye. Robert Rivas? Aye. Robert Rivas, aye. Luce Rivas? Aye. Luce Rivas, aye.
That bill is out.
Thank you.
Thank you. So we will now move to item number 1, AB 2029. Ms. Bonta.